All rise. The Honorable, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state in this honorable court. Be seated.
Welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge John Arrowood, and to my left is Judge Chris Freeman. Assisting us today are Deputy Clerk Roderick McFarland and Officer Tom Salute. Thank you, gentlemen. On the calendar today, we have N-Ray Trade Land Company, LLC, on appeal from Wake County Superior Court. Counsel, are you ready to proceed? Okay. Go ahead, please. Have you reserved time for rebuttal?
I have, Your Honor, 5 minutes.
Okay, great.
Your Honors, may it please the court, my name is Bo Rodenbow with the Greensboro law firm Brooks Pierce, and I appear here today with my colleague Dan Colston on behalf of the appellant Trade Land Company. And we are joined on the briefs by our Raleigh colleague Ashley Morgan. Ms. Morgan was in fact planning to argue this case this morning, but called me midday yesterday to tell me that she had just been diagnosed by her doctor with a bad case of the flu, so she's home nursing that today.
Well, we're sorry to hear that. Please send her our condolences.
Well, she's very sorry to hear it because as a tax lawyer, she doesn't get to make many Court of Appeals arguments. And Judge Zachary, I thought I understood you to say that this was on appeal from the Wake County Superior Court. It's actually
yes.
from the North Carolina Property Tax Commission.
Okay.
And
because our briefs say Wake County. I know it's from the Property Tax Commission, but the briefs say from Wake County, so that's why.
All right. Thank you. Your Honors, this case presents a very simple issue to the court, and that is whether the Property Tax Commission properly relied on GS 105-394 subsection 9, a provision that has been held to be unconstitutional by the North Carolina Supreme Court for its conclusion that the Pitt County tax assessor's failure to timely notify the taxpayer of its decision to remove their properties from the present use value program was a mere immaterial irregularity.
Do you concede that the notice was not? Oh, you okay?
Yeah.
Not concede, but it is your contention that the notice was not given as prescribed, right? By 105-296.
Correct.
Okay. So it's your contention that basically what's before us now is merely whether that lack of proper notice was an immaterial irregularity.
No, Your Honor. What's before you now is whether the immaterial irregularity statute, which other than for the lack of notice, actually applies to immaterial irregularities.
Okay.
Things like a failure to to have a seal on the, or to properly identify the property in the ruling and so forth. Unlike those things, the North Carolina Supreme Court has held that subsection 9, which says that the failure to give notice in accordance with 105-296I and 105-277.4, subsection B1, is an immaterial irregularity. The North Carolina Supreme Court.
Now, let's talk about Osteen just a little bit here.
Okay.
What happened in Osteen was there was no notice, isn't that correct? And what the court said is, we hold that the giving of notice of the docketing and the judgment and of the sale under the execution required by 105-392 is indispensable to a valid sale under the statute, and that the provisions of GS 105-397.1, now 105-394, to the contrary, is in conflict with Article 1, Section 19 of the Constitution of North Carolina, and the validity of the remaining provisions of the statute is not properly before us. Isn't that as applied challenge, not a facially challenged constitutional argument to this statute?
That is an as-applied challenge, Judge Arrowwood, and we believe that the same analysis applies as applied in this case.
But your client got notice, had an opportunity to go, presented their case, and lost. Isn't that correct? And they even got to pick the date.
They did not receive meaningful and timely notice and an opportunity to be heard, and I'll explain why, Your Honor. Here, the taxpayer had submitted information in response to a 2021 audit request by the Pitt County Tax Assessor. At January 25 of 2022, the Pitt County Tax Assessor affirmed, based on that audit, that these 11 properties were properly placed in the PUV program.
But you conceded at the Property Tax Commission that your client was not entitled to PUP, did you not?
We did.
Transcript 9, page 9, I believe.
That's correct. That's correct. And we pointed to the fact that in that tax audit, we stated to the tax assessor that the taxpayer, Trade Land Company, was not engaged primarily in agriculture, horticulture, or forestry. Had we been given the opportunity to meaningfully challenge this determination to take the tax assessor's decision to reverse its earlier audit decision in the same year, January of 2022 versus December 5 of 2022, when they gave us notice that they were now deciding to withdraw it from the PUV program, we would have been able to go in and challenge that determination.
But how have you been harmed if you concede that your client was not entitled to PUV status? You got notice and your client wasn't entitled to it. So how have you been harmed?
Well, we have been harmed because had we gotten timely notice before the first meeting of the Board of Equalization and Review at April 5 of 2022, we could have retained counsel who could have advised us that we needed to challenge that determination that the properties were not primarily agricultural, horticultural, or forestry products.
But if you concede that it's not only do the properties have, as I understand it, and I am not a tax expert, so you can correct me if I'm wrong here. My understanding is it's not only do the properties have to be, but that the owner also has to be primarily engaged. And you've conceded that the owner is not primarily engaged. Isn't that what your concession at the Property Tax Commission was?
That was the concession at the Property Tax Commission, and that was the statement that was made in the tax audit request by the taxpayer at the time. The tax assessor, however, Russell Hill, acknowledged in his testimony before the Property Tax Commission that under the Department of Revenue's PUV manual, the primary way that you determine whether or not an entity is primarily engaged in agriculture, horticulture, or forestry, that is farming more broadly, is to look at the business income from the properties, both the farm properties and the non-farm properties. Mr. Hill acknowledged at the hearing before the PTC that he did not have the information to make that determination, that he had come in as the new tax assessor in June of 2022 and had thereafter in October of 2022 discovered that Trade Land Company had sold a piece of property for $2.5 million for a new sheets, and that prompted him to look back at this primary farming classification for the PUV program for the taxpayer.
But didn't your client complete those forms every year saying that the entity was not primarily engaged in farming?
They completed one tax audit for him, and they in their original applications disclosed that they were not primarily engaged in farming at the direction of the then tax administrator.
So if they're not primarily engaged, if that entity is not primarily engaged in the proper activities, then were they ever entitled to PUV status without changing the entity?
They may have been, Your Honor.
If they had created another entity?
They could have created another entity.
Which they've done now.
Which they've done now.
Yes.
And so but if they had received timely notice, they could have challenged by looking at the income from all the farm properties and the non-farm properties that were held by Trade Land Company, and presented evidence to the Board of Equalization and Review that they did in fact, the business entity did in fact qualify.
Did you argue this before the Property Tax Commission?
I did argue this before.
That they were actually qualified?
No, not that they were actually qualified, but that they could have been given the opportunity to present evidence on that.
And were they given the opportunity to present evidence in December of that?
They were given the opportunity to present evidence, but they had 7 days from the December 5th notice of this hearing to marshal that evidence. They didn't have time to retain counsel. They thought they were going to do it.
Did they pick the date? They were given 2 dates, and they picked the date, correct?
There again, they were told, you can present this to the last session of the Board of Equalization Review in this tax year, 2022, which is on December the 12th, or if you want to, we'll let you postpone the hearing until the first meeting of the Board of Equalization and the Review in the spring of 2023 that hasn't been set yet.
And why didn't they want to do that?
Well, the two problems with that are there's no provision for doing that under the Machinery Act to postpone the hearing. The Machinery Act says you're supposed to have a hearing in the year that the determination is made to remove the property from the PUV program. And had they done that, they would have been prevented from creating a new entity. If they waited until 2023 for the hearing, then they would have been prevented from creating a new entity that was composed of only farm properties. And the county tax assessor would have contended that that wasn't a valid reapplication to the PUV program in 2023, because at January 1 of 2023, they were still in Trade Land Company. So both the lateness in the year and the inability to create this change prevented us from postponing it until 2023. If we had waited until 2023, the county tax assessor under the Machinery Act could have said it's not proper to hear this in 2023, regardless of whether they had told them December of 2022 that they could do that, just as the tax assessor had previously told them they could put this property into the PUV program, even though Trade Land Company was a real estate investment company and not purely a farm owning company.
Trying to understand your argument, but does the result change if the county were to provide notice at the start of next year before the board's first meeting? How would that affect your assessment of 2022 tax years and previous years?
Yes, they could. I believe that, Your Honor, that they could have given notice.
Talking about at the next meeting, how would that impact anything we're here for today?
Given that.
Yes, if we were to go forward to the start of next year, before the first board meeting, they give you the notice you're saying you need, how would that impact anything?
Then we could have marshaled that evidence that I just talked about what the income was. The county tax assessor said, I didn't have that evidence, and so I didn't make it based as the PUV program guide from the Department of Revenue says the primary way to determine whether farm properties predominate over non-farm properties is to look at the income from those properties.
But you had an opportunity, but you conceded that you did not qualify at the Property Tax Commission, so you have had that opportunity then, and you've conceded that you didn't qualify.
We did. No, we're going up to the Property Tax Commission on the record created before the Board of Equalization and Review. The Property Tax Commission is not, reviewing this de novo, and so what we had before the Property Tax Commission, at that point, there had been no evidence presented to the Board of Equalization and Review about income and so forth.
But the information provided by your client to the property, to the county, was that the entity was not primarily engaged in the proper activity.
That's correct, because based on what the prior county tax administrator had told our client this was the way to do it and that this qualified for the program. Had they been given timely notice before, Judge Freeman, in your example, before the April 5, 2023 meeting of the Board of Equalization and Review, meaningful notice, not 5 days notice, then they could have retained counsel, and that counsel could have advised them that under the program guide, we need to gather the evidence and look at the income from the farm and non-farm properties and present evidence to the board that perhaps it is, in fact, predominantly farm property based on the income. The tax assessor, the tax administrator, and you can look at the hearing transcript, pages 68 to 78, where the tax assessor talks about how he made the determination that it was primarily non-farm properties, and he did that because he didn't have income information. He did that based on looking at the relative comparison of the assessed tax values of the farm and non-farm properties held by Trade Land Company. And based on that assessment, he determined that 58% were non-farm properties and 42% farm properties. But he acknowledged that he didn't have any income information, and he didn't tell the taxpayer or request of the taxpayer any income information. And the taxpayer, having been surprised with this notice on December 5, didn't have time to retain counsel and challenge it on that basis. So, the notice, we believe, under both the decision in Henderson County v. Osteen and under the Law of the Land Clause of the North Carolina Constitution and the U.S. Constitution, the 14th Amendment of the U.S. Constitution, is you've got to be able to have not only notice, but meaningful notice and a meaningful opportunity to be heard. And we don't believe that the notice that was given here and the opportunity to be heard was meaningful.
I guess a follow-up to my question, if this court were to reverse the commission's decision, what is the practical effect? Is it simply the notice is going to be provided and the same taxes are imposed next year? Is that where we land?
No, what it will mean is that this case is now reversed, and the determination of the Property Tax Commission that you know, the immaterial irregularity provision applies in this case, is reversed, and it goes back um, in favor of the taxpayer at this point, because you know, at this point, the taxpayer has transferred these 11 properties to a new entity, Trade Family Farms LLC, which our firm created for them in December of 2022. And so they, you know, the determination that these properties were removed from the present use value program in Pitt County in Trade Land Company is now nullified.
Now, if hypothetically, if they had been given notice before the April meeting and had been told after January 1, but before the April meeting that this doesn't qualify, Brooks Pierce, having created this new entity, would not have saved their taxes that year anyway, would it? Because isn't it didn't you just tell me earlier on that it's January 1 is the date that you look at?
Correct. But what I'm saying is, if the decision of the Board of Equalization and Review that was affirmed by the North Carolina Property Tax Commission on the basis of this immaterial irregularity, applications of immaterial irregularity statute is reversed by this court, then there is no further review of.
Well, I understand what you're saying. I'm just trying to look at the practical effect. If there had been notice after January 1 and before April 25th or before the April meeting that we're going to revoke it, then you're still in the same situation, are you not, as you are in December?
No, you talking about January 1 of 2023 now?
No, January 1 of 22. You're saying you had to give us notice before April 25th so we could challenge it.
Correct.
But whether you qualify or not is determined on January 1 of 2022.
And Your Honor, had we been given timely notice, we could have marshaled the evidence to prove that we did in fact qualify, even though we had checked the block on the audit form that said we were not primarily engaged in farming. We could have marshaled the evidence based on the income received from these properties to make the case to the Board of Equalization and Review that they in fact did qualify.
Did you present that evidence at the Board of Equalization and Review?
No, we didn't present that evidence at the Board of Equalization and Review because these are lay people. They didn't have time to retain counsel between December 5 and December 12. They naively and wrongly thought we're going to go into the Board of Equalization and Review and say, look, this is the way the prior tax administrator told us to do it. This is the way we've done it. And we've never, you know, hid the ball from anybody. This is not newly discovered facts. The facts at January 1 of 2022 or at January 25 of 2022, when the tax assessor audited these properties and Trade Land Company and determined that they did qualify for the PUV program, and December 5 of 2022, when the tax assessor sent out this notice disqualifying them from the PUV program, none of those facts changed in that period. The only thing that changed is a new tax administrator came in and made a different determination than the prior tax administrator. And had we been given timely notice, then we could have marshaled that evidence. We could have retained counsel. We didn't have time.
Are you not bound by your check on the box, or could you have changed that? Your check on the box that we're not primarily engaged. Your client made that affirmative determination.
Right, based on what the tax administrator had told them when they put these properties into the program.
What is their ability to rely upon the tax administrator's recommendation as opposed to getting counsel? Who bears that responsibility?
Well, they do, Your Honor, but again, if they had been given timely notice that the tax administrator had changed their view, then they could have retained counsel knowledgeable about the PUV program guide issued by the Department of Revenue that says the primary way that you determine whether farm properties predominate over non-farm properties in a business entity is to look at the income that is received from the farm properties versus the non-farm properties.
Did your client request a date later in the month so that he could retain counsel?
No, Your Honor. The two choices that they were given by the tax assessor were to appear before the last meeting of the Board of Equalization and Review in 2022, which was December 12, 2022, or to wait until the spring of 2023 to appear before the Board of Equalization at a hearing that had not then even been set yet. And so, again, the taxpayer here are lay people. They're acting in good faith and reliance on what they've been told by the tax assessor, and they genuinely believed, oh, we'll go and get this straightened out. The Board of Equalization and Review, we did what the tax administrator told us to do, and the tax administrator in this same tax year has already affirmed that we do qualify for the PUV program. And then the tax administrator changes and a new tax administrator comes in at the very end of the year in clear violation of the notice provision and reverses that determination. They had no idea what they needed to do from a legal standpoint to challenge that decision, but they thought from a good faith and layman's standpoint that we'll go in and present this evidence to the Board of Equalization and Review, and they'll affirm us on this.
What evidence did they present? Can you remind me of that?
What evidence did they present to the Board of Equalization and Review?
Yeah.
They presented their original applications, and the tax audit findings from the Pitt County Tax Assessor. But they didn't have an opportunity to retain counsel, and they didn't know about the PUV program guide issued by the Department of Revenue, which County Tax Assessor Russell Hill said is our Bible and what we do in making these determinations. And again, the County Tax Assessor acknowledged that he didn't make this determination based on the income information, because he neither requested that nor had that information available.
You're just right now getting into your rebuttal time.
Well, I think I've made the arguments that I want to make about why this is a clear violation of the opportunity, having a meaningful opportunity to be receive notice and be heard, and also that this clearly fits within the ambit of the decision of Henderson County v. Osteen, which says that a notice required under the Machinery Act, whether it's for the sale of property or for, in this case, removing a property from the PUV program, is not an immaterial irregularity and violates the law of the land clause of the North Carolina Constitution. We would argue that under Price v. Slagle, which is a 1925 decision of the North Carolina Supreme Court, which says that here's what the Slagle Court said in 1925. The requirement of notice of the defaulting taxpayer, who is the landowner, may be prescribed and regulated within reasonable limits by the legislature, but cannot be dispensed with. Such a requirement is subject to the test of due process of law. Here it was completely dispensed with. There was no meaningful notice and opportunity to be heard, this taxpayer in this case. And in fact, in the same tax year, the Pitt County Tax Administrator, at January 25 of that year, determined that these properties did qualify for the PUV program. And then at the end of that tax year, when there was no longer time for the taxpayer to retain counsel and challenge that decision, the tax administrator sends notice that they're now disqualifying the taxpayer from the PUV program. That is a complete absence of meaningful notice and opportunity to be heard, and a violation of the statutory requirements. And I would also note, Your Honors, that the North Carolina legislature has, since the decision of the Supreme Court in Henderson County v. Osteen, has reenacted and amended those notice provisions that I cited at the outset, 105-394,
Okay, you're getting down to using all but 2 minutes of your rebuttal time.
All right. Thank you, Your Honor.
Do you have
I
any
will
further
sit down.
questions? Do you have any further questions? Okay, thank you.
Good morning. May it please the court, my name is Matt Gibson. I'm representing Pitt County in this matter. The Property Tax Commission correctly affirmed the Pitt County Board of E&R's decision to disqualify or remove the subject property from enrollment in the PUV program for the 2022 tax year. The record shows trade land was not a qualifying entity under the PUV program and was properly removed. Upon noticing the disqualifying event, Pitt County provided adequate and sufficient notice of the removal and an opportunity to be heard, which satisfies procedural due process.
Do you agree that you didn't provide notice as prescribed by 105-296I?
So I believe we did prescribe notice. I believe that 105-296I has 2 sentences. Now, one of those sentences speaks to the appraisal. One of those sentences speaks to assessment. I believe under 296I, we provided notice that included, so I guess we would start with 105-277 4B1, which says that notice should be provided in accordance with 296I. And in that notice provision, it says that notice must be provided that includes the property's tax ID number, which was included, the specific reasons for the disqualification, which was included, and the date of the decision, which was included. It also states that it needs to be provided, written notice needs to be provided to Tradesland's last known address, and so here, because it's an LLC, it would be the registered address. And so it was sent, and we know that notice was received as they did attend that hearing and had an opportunity to be heard. As to your specific question about I, again, I believe 296I, the first sentence of it, speaks to the appraisal and says that it cannot change within the current year. The second sentence speaks to that notice needs to be provided for assessments, but it does not say within the current year. And I think that being able to provide notice 8 months in advance of recognizing a disqualifying event is unattainable. Specifically to that question also, in the provision of 296I, underneath it, 296J gives the assessor the opportunity, requires the assessor to audit programs every 8 years. Has to audit a number of them every year over an 8-year time frame. And in that, it requires or allows the assessor to ask for additional information. From that additional information, the taxpayer has 60 days to provide that notice. So if we go into 2022 and we determine that this PUV program may not be allowed in the PUV program, we may ask for information. Say that happens in February. Well, the taxpayer gets 60 days to provide that information. If they provide that information after the first meeting of the Board of E&R, according to the appellant, we no longer can take them out of the program for that year. And so my argument is for 296I, that notice would need to be provided before the first meeting of a Board of Equalization review. So if it happens after the first meeting of 2022, then it needs to be provided before 2023. I think essentially it comes down to 105-277-4C, which states that deferred taxes are due and payable in accordance with 105-277-1F. Now, when are they due and payable? Well, 277.1F says on the day the property loses its eligibility. So how does one provide or have to wait to provide notice when immediately these taxes, which are liens on the property already, these aren't new taxes, these are deferred taxes that are liens on the property. If they are already on there and they become due and payable, how are we not allowed to provide notice on that day that they become due and payable?
Well, how do you address the your counsel across the aisle who says that there is not meaningful, that his client did not receive meaningful notice and that meaningful notice is required under Osteen?
Sure, and I believe, as Judge Edward, as you stated, I believe Osteen is determined that the statute was unconstitutional as applied and not on its face. I believe
what's meaningful notice?
I believe meaningful notice would be subjective, but I believe in this case meaningful notice was provided. Notice was provided that they were removed as soon as we found out the disqualifying event. We provided them notice. We gave them the opportunity of having a hearing a couple days later, which would have been our last one, or they could have waited. Did they want to go ahead and resolve the issue and have the hearing and determine what they needed to do? Or did they want to wait until the spring date and at that point have the hearing?
Well, if they had waited till the spring date, would they have, I believe the argument is they would have forfeited their ability to get anything back in 2022 anyway. I believe that was the argument I heard. Is that correct? That they would have, if they had waited till the spring date, would they have forfeited the?
I do not believe so. So I believe that,
why?
As the statute states, it's due and payable on the date that the disqualifying event occurs. So just because the hearing occurs a couple months later doesn't change the fact that the taxes become due, because they are liens on the property, becomes due on that December 5th date. And so essentially what the county would argue is that they had a meaningful opportunity to be heard. They determined to go ahead and handle the matter before the January 1st date of the new year. Specifically, I would also point that in those statutes, both 105-277-1F as well as 105-277.4C, does not say in the current year. So an argument could be made, Your Honor, that it's not when we notice it, it's when the disqualifying event occurs. And so even if we would have had to wait, provided notice, we still could have gone back to the disqualifying event of when it happened. Hypothetically, Judge, we could have gone back all the way until 2022 or 2021 if we provide evidence to our tax assessor and ultimately, if it's appealed to the Board of E&R, that the disqualifying event happened then.
Well, why are you not bound by, I've asked them why they're not bound by saying that they don't qualify in the audit. Why are you not bound by what your current tax assessor at that time said? How can you change, if they can't change horses in the middle of the stream, how can you?
Correct, Your Honor, and I agree with that. I believe there's case law out there that states that the tax department cannot be a stop for mistakes that employees make. And as this procedure happens, Pitt County, even though it's not a
Is the assessor an employee or is the assessor an officer of the county?
So the assessor would be appointed by the board, would be at I guess there's a differentiation between public official and public employee, but they are appointed by the board. But again, I believe, as we know how government works, the assessor may not have investigated or audited every specific Pitt County property that occurred, and these would be employees that would be doing it.
Did the sale of the sheets precipitate the audit?
It did, Your Honor. And so notification was brought to our land records manager. That was again brought to the tax assessor, Russell Hill. So this one specifically was brought to the tax assessor, Russell Hill. He was notified, determined that these parcels should not be in the program. Did further investigation, determined that the 11 parcels as a whole for trade land should not be in there, and essentially sent notice immediately to let them know they were no longer in the program.
What about his testimony that he didn't have all the information necessary in order to make that determination of the Department of Revenue guidelines?
And Judge, I cannot speak to his testimony that occurred, but I believe during the PTC hearing, he did not have all the information with him to be able to make that determination as to whether they would be in the program or not. But the evidence that was provided both to the Board of Equalization Review as well as to the Property Tax Commission did not contradict that they did not qualify for the PUV program. So again, the Board of Equalization Review as well as the PTC was not provided information that this was an eligible program, and to this date, no evidence has been presented since to allow them to be in that program. I would also say that, again, the statute is clear in 105-277-3B21, which speaks about continued use. And so I believe Mr. Rowenberg spoke about being able to gather information to transfer this property into an eligible entity or individual for this. But in order for that to happen, the person that is transferring title would have had to have been eligible. And trade land was not eligible, and so the continued use would not apply in this situation. And so, Judge, I don't believe that would precipitate us, not affirming the Property Tax Commission. I would also state, and we've spoke about but again, I will state, again, going back to 105-296I, that it does prohibit the assessor from changing the appraisal during the current year, but that's not what this occurred. The county did not raise or lower the appraised value. The true value of the present use program, the true value and the present use program remained the same, and the county just removed trade land from the program. That statute is clear. North Carolina General Statute 105-277-6 requires the appraised true value and the present use value to remain the same until it is required by law. The county assessor is required to use the present use value standards, schedules, and rules to appraise the property until the next reevaluation year. So we were not changing the true value. We were not changing the present value. All that was happening is we were taking it out of the present use program and allowing for the deferred taxes, which were already liens on the property, to be due and payable at the time of this disqualifying event.
When did the disqualifying event occur?
So, Judge, I guess the disqualifying event occurred, the argument could be all the way back when they initially applied for it and they were not eligible but placed into the program. I don't believe...
If the disqualifying event occurred then why are we not bound by the April date if that's the disqualifying event?
Correct. And I don't believe that a mistake by a tax employee can stop from taxes being assessed fairly and equally throughout the community. And so I think that as case law has stated, I believe that we need to assure that the distribution of property of taxes is in proportion to the true value, and it eliminates unlawful discrimination of all properties in the county. And so I believe just because of a mistake by an employee does not allow them to circumvent the tax code and allow them to be in the present use value program, even though they were not eligible for it. Judge, I believe I've spoke about the majority of the issues. I will state that in 105-277.1F, when it speaks about on the day the property loses its eligibility, it also says that tax for the fiscal year that begins in the calendar year in which the deferred taxes are due and payable is computed as if the property had not been classified for that year, for that whole year. And so I believe, again, 277.1F speaks to allowing the tax or the tax assessor to remove any property throughout the whole calendar year that is not a qualifying entity under the present use value program. I believe both the Pitt County Board of Equalization Review and the Property Tax Commission properly removed trade land from the PUV program and provided adequate and sufficient notice, and as well as an opportunity to be heard. So Pitt County would respectfully ask this court to affirm the Property Tax Commission's order, but I'm here for any further questions. Thank you.
Thank you, sir.
Very quickly, Your Honors, the statutes that Mr. Gibson recites to you concerning when the disqualification becomes effective have nothing to do with the notice and an opportunity to be heard. We don't dispute that if you determine that for the 2022 tax year, property's been disqualified, then it comes out of the PUV program and you're obligated to pay taxes for that tax year plus rollback taxes for the up to 3 preceding years. Now, in this case, it wasn't fully 3 preceding years for all the properties because three of them were placed in the PUV program in 2018, 1 in 2019, and 7 in 2020. So as to those 7, there were only 2 years of rollback.
I have one question, and this may go over, and feel free to use more time. I'm back to Osteen again, and it talks about the giving of notice of the docketing of the judgment and the sale upon execution. And you keep talking about reasonable notice and reasonable time. I don't see the word reasonable anywhere in Osteen.
Well, because it's not in Osteen, it's in the North Carolina Constitution and the Due Process Clause of the 14th Amendment of the U.S. Constitution that require meaningful notice and opportunity to be heard.
And what is meaningful and what is reasonable? How much would it have had to have been?
Well, I think in this case, Your Honor, that the Machinery Act sets forth what is reasonable, and that is that notice has to be given before the first meeting of the Board of Equalization and Review in the tax year in which you want to disqualify the property.
What if the disqualifying event happens after April 25th?
Then you would present that evidence in the next tax year, and it would be disqualified at that time. And
you could go back for 3 years and get it.
Right. Correct.
And so doesn't that work to your client's disadvantage, though, as you explained to us earlier? If they had said, okay, now you're going to be heard, you can't be heard now, we're going to put you off until the first meeting of the board.
And had they done that, then we would have gone out and changed we would have taken these 11 properties and put them in a new entity that only owned farm properties, or we would have.
But you did anyway.
Huh?
But you did anyway after this hearing.
We did, and the Pitt County tax assessor challenged that. We did that not to defeat the 2022 determination and the rollback taxes that were due, but in order to qualify these properties for 2023 and years going forward. And because we were unable to transfer those 11 properties from Trade Land Company to Trade Family Farms, LLC, until January 4th, 2023, the tax assessor contended that these properties should not be qualified for the PUV program in a qualifying entity, that is Trade Family Farms, LLC, for 2023.
Because it wasn't in the qualifying entity as of January 1st.
Correct. And we appealed that decision to the Board of Equalization and Review, and the Board of Equalization and Review affirmed us and included those properties in the PUV program for 2023 and subsequent years in Trade Family Farms. They overruled the decision of the tax administrator in that case, and the records of those proceedings are in the documentary exhibits that are attached at under Rule 9D. So that's what we could have done. If they waited until 2023, we would have gone ahead and done that, and there would have been nothing for the Board of Equalization and Review to hear in April of 2023.
Okay, thank you, sir.
Thank you.
That concludes oral argument in this matter. I will take this under advisement. Thank you, counsel, for your arguments today. We may adjourn.
All rise. This session of the North Carolina Court of Appeals is now adjourned.
See it?